I think Bernard has shown us, that you can be very brief and be very interesting. I think this is something that Winston Churchill has already covered this point, so I will not entertain you longer. And since Bernard, I think, is very tired, I'll have the pleasure to introduce a colleague of Bernard of the same chamber. Oh, you want to introduce?
May I introduce him?
Yeah, I know there is a story between you and Roderick.
A very quick story is that Roderick and I, many stories, Roderick and I were at university together, so I have known him, believe it or not, for over 40 years, I think, and he has been a close friend and a great working colleague. He is a QC in London. He does a lot of shipping work. He is very well known in London, and I very much look forward to his speech, and which I introduce him. I think he's going to speak from here.
Yes. Signore e signori, è per me un onore essere qua a Napoli per questa conferenza e salutarvi nella madrelingua, lingua madre dei miei genitori. I am very keen on the closeness of the ties between Italy and the United Kingdom, and I am an insignificant personal embodiment of that, being the English-born son of Italians. When I'm in England, I feel Italian. When I'm in Italy, I feel English. It's hard work, but I enjoy it. And I'm here to talk about the subject of contractual interpretation. And what I'm really after is a fusion, if it's possible, of two very great maritime traditions. Italian maritime history is second to none. The United Kingdom has a much shorter history, of course, but nonetheless, I hope we can agree, a distinguished one, and in particular, of course, maritime law, invented in the Mediterranean and not yet perfected, although once the Court of Appeal have decided the point that Bernard just spoke about, it may well reach that moment of perfection. Now, the interpretation of contracts is a difficult process at the best of times when you just have a contract between A and B. What did they agree? It's very difficult sometimes to tell. But the bill of lading is probably the most complex, flexible, brilliant, and frustrating form of contractual obligation that exists anywhere. And that is because, as you know, it's transferable. So it will come into the hands of and be enforced by people who were in no sense known about or foreseen when the bill was issued. It functions, needless to say, in many different ways. It's a receipt, it's proof of title, but importantly for my talk, it is evidence of a contract of carriage. And that is something which is very essential to what I briefly consider with you for this reason, that when you are trying to understand the intention of two parties to a normal contract, at least you know who they are. But in a case involving a bill of lading, you are trying to understand the supposed intention of parties who may well no longer be on the scene. And at this point, I must mention a group of unfortunate people taken for granted, rarely discussed, inadequately rewarded, and mentioned only when they are being criticized for their lack of understanding of the ways of the commercial world. I mean, of course, the judges. And it is they who have the task of interpreting these difficult contracts. And the guide that I'm going to use, as I quickly take you through the English cases on this subject, is one that comes from the writings of an English mathematician of the 19th century, the creator, known as Lewis Carroll, the creator of famous children's stories in the English language, and the creator of a character, Humpty Dumpty, who is a large egg who sits on the wall, and every English-speaking child learns of his unfortunate demise as he falls off the wall. But before that, he's interviewed by Alice, the young 7.5-year-old girl, and he says this about language. He says, and I quote, "When I use a word, it means just what I choose it to mean, neither more nor less." And the little girl says, but the question is whether you can make words mean so many different things. To which Humpty Dumpty replies, the question is, who is to be the master? That's the question. And the case law, which I'm quickly going to take you through now, is case law which goes into 3 phases, and I will mark each phase by reference to the Humpty Dumpty scale. The Humpty Dumpty scale goes from 0 to 10. It is at 0 when one simply looks at the words and allows them to be the master. And it rises through to 10 when one looks at the words and one decides to be the master. And judges are constantly facing, in these cases, owners on the one side who want to have one place when the cargo is discharged and it's discovered to be damaged. Owners want to have one place for the litigation, preferably the arbitration, usually. One answer, and preferably, obviously, in a climate which gives the owners the maximum exonerations. Sadly, that's outside the scope. Cargo recipients obviously want, generally speaking, to have the litigation at the discharge port, where they are familiar with the court, possibly even related to the judges, and feel that there is a greater chance of success. So the general trend is for owners to seek to argue for arbitration and to face the challenge of making sense of the bill of lading, and for cargo to seek to take the most destructive position possible. And of course, as you can see from the slide, this is a form, the problem is essentially one of crowd control, as I've already described. The problem, of course, is made worse by incompetence, casualness, and drafting problems with which we are all familiar and which will never go away. The solution, as I've said, is to develop a technique whereby one can draw a balance. The words are not the master, but equally, one wants to reach a conclusion which reflects the intentions of the supposed parties. This is entirely fictional, but it has to command confidence. The old school, the older English cases, and some are mentioned on the screen, are cases where the judges took a very hands-off approach. Thank you. If, for example, the words of incorporation said clause 30 of another document, and in fact it was obvious that the words should have read clause 32, the judges said, there's nothing we can do. And arbitration clauses are clauses, jurisdiction clauses as well, which require specific wording according to the case law. And the directionality also of the analysis was very much just to look at the bill of lading and not to peep and see where the point of possible arrival was the charter party and what it said. And it might often set out the wording of the hoped-for bill of lading, which, of course, one may or may not, in fact, have in one's hands. The old school, around the turn of 1970, began to slowly crack. And cases began to emerge where there was some degree of manipulation. And the Humpty scale, we moved from 0 out of 10 on the Humpty Dumpty scale to maybe 2.5 out of 10. And then the middle school comes, gloves off, hands on. And cases like the Onusium Pride and the Nerano, cases where the judges became much bolder, where owners' counsel was succeeding for the first time in persuading judges with difficult and incomprehensible language to take it by the scruff of the throat, and with this new trend to try and make it work. And then a slight retreat, but a case perhaps de reculer pour mieux sauter at the end of the 80s, and then the new school. And cases such as Calang No. 2 and Yalam Mars tankers are cases where one has a far more interventionist approach. And lucky lady, unfortunately, for the owners, they lost. But in caress navigation, there was, as you can see from the bottom bullet point, an arbitration clause incorporated. The only problem was there was no arbitration clause. So, raising the score now to 9 or possibly 10 out of 10 on the Humpty scale, the judge decided that arbitration must mean litigation. So that was splendid. And in terms of the position where we find ourselves, the earlier cases, Merak being one of the earlier cases, are now described in the English judgments as unusual, very old-fashioned, and outdated. And then there's the golden endurance, which time does not permit me to go into, but very much of the new school. So Humpty Dumpty's prediction has been fulfilled. But nonetheless, I expect that the cases will continue. Now, in researching this talk and looking for a connection between the United Kingdom and Italy, I made a discovery. We all know that in 1798, events took place in the bay just outside the city involving the imminent arrival of Napoleon, the arrival of the Royal Navy under the command of an admiral whose name I have been told not to mention, in order to rescue his girlfriend, and who was the wife of the British ambassador, again another name I have been told not to mention in Naples, because they're not popular names. And they also rescued the Bourbon king and queen at the same time. And they sailed away as Napoleon entered the city. What is not so well known is that on that boat was a cardinal, a British cardinal by the name of Henry Duke of York, who was the Stuart claimant to the British throne. And he had become a cardinal. His older brother, Bonnie Prince Charlie, had failed in his attempt in 1745 to seize the British throne from the German Protestant Hanoverian house. Why do I mention him? Well, he, being a cardinal, left no children. But he left his claim to the British throne to his nearest living relative, who happened to be Emmanuel Victor, Duke of Savoy and King of Sardinia. And presumably, although I stand open to correction, when the Republic, the Italian Republic, was founded, all the claims of the royal family passed into the hands of the Republic. So, in the turbulent political times that we in the United Kingdom may well have ahead of us, possibly leaving the community, perhaps with Scotland leaving us and returning to the community, if the Scots need a potential monarch to take the place of the existing arrangements, I presume whoever is the incumbent of the Palazzo Madama at that moment will be able to offer his or her services to the people of Scotland. So you see, destiny has organized matters so that these two great maritime nations may once again, after a short gap of 1,500 years, come under one administration. Thank you very much indeed.